Liberty Fighters Network.
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 Good day, liberators and fellow South Africans. Sadly, I'm going to be the bearer of further bad news about our very constitutional court. People, I'm going to share with you information and prove that the constitutional court is either captured, which I believe they are, or that the judges have become incompetent and that they don't know the law themselves. And that would be strange, wouldn't it? So I'm going to rather go for the option that the Constitutional Court has merely become an extension of government. And everything that has been happening more than the past 2 years surrounding COVID-19 and everything that happened during those periods. People, I'm calling on the good members of the legal fraternity to become vocal. It's your judiciary. It's the courts that you are officers and serving. So if the courts become rogue, which I believe they are at present, it's the legal fraternity who needs to come out and do something about this very seriously. Because every time when a lay litigant like myself finds the judiciary with their pants down time and time again, and it has reached the point whereby the judiciary is attacking me and Liberty Fighters Network. My court case for contempt of court against the Supreme Court of Appeal will be heard or will commence anytime soon. I've already received confirmation from the Director of Public Prosecutions of the Free State that the NPA is planning to institute criminal proceedings for contempt of court against me. So that is something that is going to be very interesting to follow, and I will ensure that the media and cameras are there to follow each and every step of the way so that there cannot be something underneath the table done again. People, it's time that we become really vocal about what is going on. And let me show you what has happened now recently. In stealth once again. And people, this needs to be shared with as many as possible people. The public must be informed about this. We must know the enemies that we are currently facing. And sadly, our courts have shown that they cannot be trusted. And they have become possibly enemies of the state, enemies of the people. And we need to take the stance to tell the courts that we're not going to tolerate this rogueness of it anymore. So share this. I don't know how long this is going to be, but everything is going to be very, very, very important, because I'm going to show you the proof so that you can know that what I'm saying can be verified. And again, it's your decision at the end of the day, whether you're going to align yourself with our approach or opinions, or whether you're going to make up your own. But let me give you the information so that you can make an informed decision. Firstly, and people, remember to share this, like this, and subscribe to our channel, and possibly consider joining us. But let me, without further ado, let me remind you about the court order, the High Court order that we have obtained on the 2nd of June 2020, where Justice Norman Davis has declared the Disaster Management Act regulations at that stage as unconstitutional and invalid. He has given then a 14-day suspensive period, meaning that for that period it will remain valid in inverted commas, but by way of this supervisory order that he has crafted, the minister was supposed to review and rectify those regulations and then report back to court within the 14 days. Now, here is where the problem comes in, and which is relevant to what has happened now recently in the Constitutional Court. Now, when an application for leave to appeal is lodged with court against an order made by the court, that very court, in terms of not only the common rule, but the common law, but Section 18.1 of the Superior Courts Act of 2013 specifically says that upon a filing of leave to appeal, the order, the operation of the order and execution of the order is then suspended, pending the outcome of the appeal. So now what has happened was that on the 5th of June 2020, the Minister of Cooperative Governance and Traditional Affairs, Dr. Dlamini Zuma, she lodged her application for leave to appeal against the order of the 2nd of June. So technically, many legal practitioners think that the suspensive period has also ended, but it did not. And why do I say that it did not end? And why did we afterwards say that the court order, irrespective of the application for leave to appeal, has come into operation by the 24th of June 2020, meaning that all the regulations that have been there were automatically null and void, and it's no longer there. Why did we say that? Because the Constitutional Court said so. And let me take you to that court and refresh you. Way back in 2013, in 2006, the Constitutional Court in Minister of Health and Another versus Nuclic South Africa and others, 2006 JOL 17488CC, Constitutional Court, made, and sadly, this court judgment is not found on Safely. We had to get someone to provide this judgment for us, and in this, the Constitutional Court at paragraph 16 said, the common law rule that execution of a judgment is suspended pending an appeal has no application to declarations of constitutional invalidity of legislation. And there it goes on. So it means that the suspension is not valid. So it does not suspend it. We further go on and to show you that in the Supreme Court of Appeal, we've made this argument from the very beginning. In the Supreme Court of Appeal, it was in fact our second point in limine, whereby we have said that in this Nuclic's case, the Constitutional Court had no authority to revive the order because it has already lapsed. There are no regulations since the 24th of June, and we've cited paragraph 16, and then further, very important here is that in that very same Nuclic's case, this provision enables a court to regulate the effect of an order of invalidity pending an appeal. A litigant who considers that it would be just and equitable for an order of invalidity to be suspended pending an appeal should make timeliness and appropriate application to the court considering the application for declaration of constitutional invalidity and draw the court's attention to the relevant considerations of justice and equity. And then the court that makes the declaration of invalidity is the court that is best placed to determine what is just and equitable in the circumstances and whether an order suspending the declaration of invalidity should be made pending the appeal. So, people, this Nuclic's case said that irrespective of the lodgment, remember that the Constitution of South Africa is the supreme law of the land. So all other legislation, inclusive of the Superior Courts Act, cannot clash with the Constitution. If the Constitution in section 172 says that the High Court makes a declaration of invalidity of in this case, delegated legislation, the regulations of the National State of Disaster Management Act regulations, the court must then suspend the operation thereof. So the power of suspension is not an automatic process by way of filing an appeal. It is regulated in terms of section 172, where the court then determines whether there should be a suspension pending the appeal, yes or no. This was never done in our particular case. Hence the reason why we time and time again put it before the Supreme Court of Appeal, and we have also put that very argument before the Constitutional Court. Now, people, let me just go to this very interesting case that happened recently. Okay, this is a Supreme Court of Appeal matter. It was heard on the 8th of September. It's in the matter of Agribusiness NPC, which is now Sake Liga, versus the Minister of Finance. And in this judgment, the Supreme Court of Appeal has declared that the preferential procurement regulations of 2017 are invalid. And here, the Supreme Court of Appeal have said that the declaration of invalidity referred to in paragraph B, it's here, B, is suspended for a period of 12 months from the date of this order. So in that case, Supreme Court of Appeal case, the declaration of invalidity was suspended for 12 months. Okay. Let me show you what happened thereafter. The minister went on an appeal, and in the appeal to the Constitutional Court, it's the matter of Minister of Finance and Agribusiness. Here, there's the citation, Minister of Finance versus Agribusiness NPC 2022 ZACC4. Okay. Now, in this case, the Constitutional Court confirmed the Supreme Court of Appeal judgment. Okay. But then something strange happened. Very out of place by the Minister of Finance. And I'm very much tempted to say that this was a deliberate attempt of government to create new law, to create a new judgment for the Constitutional Court, which ultimately suspend or makes the new Kicks case to be totally forgotten. The Minister of Finance then went on, and he then made a very odd variation request to the Constitutional Court. And even the court itself said that, well, this is a very much strange. We don't know what is going on, but this is Minister of Finance versus Sake Liga, previously known as Agribusiness NPC and others 2022 ZACC 17. Now, the reason what the minister said basically was that the order that the Constitutional Court granted on, when was that? On the 20th, it was heard on that day, and it was made on the 16th of February this year, 2022, was vague and embarrassing. Because, coincidentally, the minister didn't know when to start to count the suspension or the appeal suspension period. Very odd. And he relied on the part of the minority judgment. There were two judgments in the Constitutional Court. There was a minority judgment by certain Constitutional Court judges, and also a majority of others. The majority of the court said something different than the minority. But in the minority judgment, it was noted that, and I'm here going to paragraph 17, they say that in the result, appeal was upheld, and the Supreme Court of Appeal issued an order that the 2017 procurement regulations were inconsistent with the Procurement Act, and the declaration of invalidity was suspended for 12 months to enable the minister to take corrective action. Now, in this footnote 28, it said that the period of suspension expired on the 2nd of November 2021. So, irrespective of the leave to appeal application that was granted by the Constitutional Court for the minister to challenge the judgment by the Supreme Court of Appeal, the minority judgment said that the period ended on the 2nd of November. And that would make total sense, because in the Supreme Court of Appeal, that the judgment was made on the 2nd of November 2020, and when you add a period of 12 months, a period of 12 months to that, it would mean that the 2nd of November 2021, the suspension would have expired. So the minority, and let's just see who the minority was so that we know the devils we are dealing with. It's Mtlantla, Kampepe, Jafta, and Chiki. Okay, sorry for the pronunciation. So they were in the minority, and the majority that was Kampepe, Jafta, Matlanka, Majid, Mtlantla, Pillay, Deron, Tlatsi, and Chiki, that was the quorum. But everyone else other than those mentioned here, Kampepe, Jafta, and Chiki, were not happy with they had the minority judgment. But leave it as it may. Now, what happened was that in this strange application that the Minister of Finance lodged, let me just go to that judgment. That's the Supreme Court of Appeal, and yeah, this is the strange application. But in this judgment, they suddenly turned around and they said that the Minister observed that the statement in the footnote was very respectfully in conflict with Section 18.1 of the Superior Courts Act. So it was unsure, and this court then said, but the suspension was then, there was a suspension, it's clear, in what effectively amounted to a reinstatement of the common law, Rule 4911 of the Uniform Rules of Court, provided then with appeal is suspended, and this rule has since been repealed, and the position is now governed by Section 18.1 of the Superior Courts Act, that's subject to subsection 2 and 3, and unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or appeal is suspended pending the decision. This too is in line with the common law position, which has already been explained. An operation which the section couples with execution, operation and execution does not alter the legal position stated above. So here the court said basically in this judgment that, it's a mere the suspension period was also suspended. As at 16 February, that was when the judgment in the Supreme Court, in the Constitutional Court was granted, of the 12-month period of suspension, less than a month had lapsed. So the court basically said that 11 months had to be counted from the 16th of February for that suspensive period. However, nowhere in that entire court application was the new Clicks case mentioned. It was as if it never existed. And the arguments and the reasons by the Constitutional Court in the new Clicks case, and which happened to have been made by 11 judges and not 9 judges as the current one did, have been properly argued and reasoned. But now, in this new case of Sake Liga, the Constitutional Court said, and strangely, they did not have to entertain that application. They did not even have to, because it was straightforward. And why they went into this strange reasoning can only be that they know that they have to rectify the wrong that they and the Supreme Court of Appeal committed in our very matter, by not entertaining our argument, not even mentioning our argument in any of their judgments whatsoever. They had to respond positively. Now the situation has changed. Notwithstanding that the Constitutional Court has never once mentioned the new Clicks case in their new judgment, they now have altered the law, and by saying that, but it is suspended. It is totally fallacious. It has effectively overruled the Constitution. The Constitutional Court in this Agribusiness Sake Liga matter has now become or made themselves to be above the Constitution. And people, this cannot be by mere coincidence. How do I know that? Is that our very NuClicks argument and the NuClicks case was before the very judges who agreed to this latest judgment in the Sake Liga matter. Let me show you that they were. Let me first go to this judgment. On the 10th of March, Yafta, Kampepe, Matlanga, Majid, Matlanga, Pele, Teron, Tlatsi, and Chiki. So they've dismissed our application for leave to appeal. So they had to have read our arguments. So they knew about the NuClicks case and our argument. And not once, but twice, because our rescission application to say that they've made a mistake in refusing leave to appeal, they did exactly the same by the same judges, who are also the judges on this very Sake Liga matter. Let me show this to you as well. There's the rescission application, which was on the 11th of August 2021, at a time when the Sake Liga matter was already heard by them. The very quorum, Matlanga, Madonda, Majid, Mlamba, Pele, Teron, Tlatsi, and Chiki. People, they knew about the NuClicks case. Why did this current constitutional court in May this year suddenly rule that the suspensive period is also suspended by an appeal? Why did they do that without mentioning the NuClicks case as if it never existed? So there you have it. People, the Constitutional Court cannot make any of its previous judgments different or change it if they have not specifically addressed those very previous judgments and said that they are reconsidering it. They never reconsidered NuClicks. They merely made a judgment which is intended, according to us, to bypass the effect of the National State of Disaster declaration of invalidity of the regulations made on the 2nd of June. That can only be for that reason, because the entire application that the Minister of Finance lodged was also strange. The judges said that it was strange, and did they not know of the NuClicks case? As I've said, that they did, because they had our papers before them the very same time when they have already heard the Sake Liga case. So immediately it would have logically sparked a, oh yes, we've dealt with this before. Although it was only in earlier this year when this strange application was lodged. You cannot forget something as important as the NuClicks case, the suspensive period, because it's something different than what the entire legal fraternity would normally argue in court. Because here, the suspension is not suspended pending an appeal because of the declaration of invalidity, which is governed in terms of the Constitution itself. So don't tell me that not even one of those 9 judges, which were coincidentally the same ones who have summarily dealt with our case and just said that there's no chance of success without giving any reasons. Don't tell me that there's not even one who know this or who know anything about the NuClicks case. People, sorry for being a disturber of peace. We will not stop spreading the truth. We will not stop to be vocal about the independence, the search for the independence of our courts. We need our courts to be reinstituted as independent organs of the Constitution, organs of the people. Until then, our rights mean absolutely nothing if our courts are not willing to enforce and confirm our constitutional rights. People, If you like this, share this, subscribe to our channel, and consider joining. Until the next time, God bless.
Liberty Fighters Network.
Liberty Fighters Network.
Liberty Fighters Network.
Liberty Fighters.